Motions in Limine, pretrial motions to exclude evidence. Brought to you by YourLegalLegUp.com, your advantage if you're being sued by debt collectors. In this video, we discuss the sort of motion that we think pro se parties underuse, motions in limine to exclude evidence at trial. All lawyers routinely make these motions, but debt defendants rarely do. Motions in limine are motions filed before trial. Limine is Latin for the word threshold, so these motions are usually brought on the threshold of trial only a few days before trial when it's pretty clear what the other side plans to do. They are usually directed at evidence, but they could also be directed at legal theories or arguments. Like other parts of litigation, they are directed at the legal merits of the case, but they could have their most powerful impact on negotiations. Or they could simplify matters for you at trial if that happens. If you can prevent the debt collector from putting on certain of its evidence, it may give up without your needing to go to trial at all. So motions in limine can be very significant. There's another reason for pro se parties to use motions in limine. As a pro se party in a system run by lawyers and judges, it can be hard to get listened to. Judges may or may not mean to pay more attention to lawyers, but they themselves were lawyers, their friends are lawyers, and lawyers are the ones they see day in and day out in court. They naturally pay more attention to them for just those reasons. And then there's the fact that lawyers understand the system and are trained in it. They can do dumb things, of course, but usually they don't. A lot of pro se parties don't really know what they're doing, and you have to overcome some expectations that come out of all of that. And then there's the fact that trials move very quickly, and the judge will be watching the clock carefully. Will everything you say get heard? Not at trial. And will you say everything that you meant to say at trial? Not likely. It's easy to forget in the heat of battle. But you have a much better chance to get heard at a hearing on a motion to exclude. That will be your chance to make an impression on the judge, explain some of the legal concepts behind the case, and make your arguments regarding evidence. All of these things are absolutely vital to your chances of success. Motions in limine are not motions for summary judgment. That is, you could argue in a motion for limine that the other side should not be able to introduce certain evidence or make certain arguments, but a motion in limine is not the place to ask for a ruling on the entire case in your favor. For that, you need a motion for summary judgment, and this comes much earlier in the process. If you did make a motion for summary judgment, your motion in limine will make many of the same points again. Debt cases usually turn on the admissibility of evidence, after all. And even if you lost your motion for summary judgment, that is definitely not an argument against a motion in limine. It's a second chance to discuss issues that will decide your case, a second chance to make the judge see it your way in a slightly different context. While you could bring a motion in limine fairly early in a case, the court will not likely rule on it before the eve of trial. And either the court will order or your local rules may provide a date before which motions in limine must be brought. In other words, there's going to be a deadline for filing your motion, and you need to know that deadline and abide by it. Most typically what happens is the court wants a list of witnesses and exhibits a week or two before trial, followed by a final pretrial conference. You would write your motions in limine in time to be heard at that final pretrial conference. There's a link below in the About This Video section to our product that could help you with that. In a debt case, everything about their case is predictable, even if you don't know for sure what they've got. Where the person suing you is a debt collector, you know their case depends on getting some bills that it did not create into evidence. You should know from discovery exactly what those bills are and where they come from long before trial. And you also need to know how they plan to get them into evidence. There are two ways to authenticate business records: an affidavit swearing to all the things required by the business records exception to the rule against hearsay, or a witness who will do that at trial. If it's by affidavit, your court may have a special rule requiring them to provide you notice of the fact in advance of trial. You must know this rule for your court. The whole case is going to boil down to whether they can get statements into evidence, and you must stop them from doing so if at all possible. A motion in limine may be your chance to do that. Here's a reminder. Rulings on motions in limine are not permanent. The court could grant your motion before a trial and then change its mind, or vice versa. You will still need to object at trial, or be prepared to argue it even if you won, in order to protect your rights. What makes motions in limine useful is that they give you a chance to make your arguments in the cool light of reason rather than the heat of trial. For the pro se, it might be your best chance to get heard. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe and comment, as all these things help others find our materials. YourLegalLegUp.com